This is day one of the spring 2024 edition of Political Economy Days lectures. I'm Peter Bowman, professor of political science and the program co-coordinator. And so for the 1245 session, we have Pippah Getchell. Pippah and I go back a long time ago, my very first semester here at Palomar, good 3 years ago. And she's been a specialist in foreign policy, American foreign policy history, American constitutional law, and American politics. And this particular topic, she has contributed many talks. In fact, we were just talking a few moments ago. I think this is her 8th different talk.
No, this is the 16th.
Oh, 16th.
The 8th year.
Oh, that's okay. 16th, 8 years, 16 different talks she's given on a variety of topics. And of course, today's topic of the Trump indictments. Of course, today is the second day of the first of the trials. The trial that seen by most people as the least serious. He only allegedly paid $150,000 to a prostitute to keep her quiet about an affair for the 2016 election and wrote off as a business expense. Nothing serious there. And then, of course, on how he took classified documents without returning them, high-profile national security documents. He tried to obscure the election or obstruct the election process. All right, after the 2020, just your standard variety, garden variety stuff that authoritarians do. So to discuss all of this, right, all the trials, the cases, and essentially everything you need to know, talking about Citizen Trump, the Trump cases in the American Republic, please welcome Palomar College's own, Cal State San Marcos' own, and University of Illinois' own, Pippah Getchell.
Thank you, Professor Bowman. It's good to be back. I was just thinking this morning about how this is the 8th year that I've been talking, and that means the 16th semester. So really good to be back. So today, I'll be discussing the 4 criminal cases against former President and now citizen Trump. All right, so these are the 4 cases. The state of New York against Donald Trump and others, which we refer to as the hush money case. The U.S. District Court from the District of Columbia, one of the elections interference cases. The other election interference case from the state of Georgia, which is also a RICO case. And last but certainly not least is the United States District Court for the Southern District of Florida is the documents case. So those common terms that I use at the bottom there, that's kind of how I'll be referring to the cases going forward. It gets a little confusing when there are a lot of United States v. Donald Trumps. You've got to be a little bit more specific here. We have 4 criminal cases to cover in a very short period of time. So I think it's best if we just jump right into the first case and then let the timeline take us from there. So the first case that we're going to talk about is the hush money case. And like Professor Bowman just mentioned, yesterday was the opening day of this trial, the first of the 4 trials, despite lots of efforts at last-minute delays. Yesterday, history was made. For the first time in our country, a former president sat in the defendant's chair in a criminal case. And although the Supreme Court will be deciding this summer once and for all whether a president is immune from criminal charges for actions he took while acting in his official capacity as president, his alleged criminal activity in this case was orchestrated before he won the election in 2016 and so has nothing to do with any official presidential acts. In 2006, going all the way back, Donald Trump was still the host of The Apprentice. He was busy promoting his brand through licensing agreements and golf tournaments and things like that. It was also the year that he allegedly had sexual encounters with 2 different women described in his first criminal indictment as Woman A and Woman B, whom we know today as Stormy Daniels, an adult film actress, and Karen McDougal, a Playboy model. So this is the case known as the hush money case, not because of the hush money payment in and of itself being illegal, but because the hush money payments were how it all started. And as is the case so often, if not for the cover-up, there would have been no crime. In the indictment, the state of New York charges Donald Trump with 34 felony counts of falsifying business records in the first degree, alleging that he repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid truthful, damaging information about him from the voting public during the 2016 presidential election. From August 2015 to December 2017, Trump orchestrated a scheme with Michael Cohen, his attorney at the time, and Alan Weisselberg, the CFO of Trump Organization, and David Pecker, the CEO of the National Enquirer magazine and AMI Media, to influence the 2016 presidential election by identifying and purchasing negative information about him to suppress its publication and benefit his electoral prospects. In order to execute the unlawful scheme, the participants violated election laws and made and caused false entries in the business records of various entities in New York, and the participants also took steps that mischaracterized for tax purposes the true nature of the payments that were made in furtherance of the scheme. In August 2015, Donald Trump held a meeting with his lawyer Michael Cohen and AMI CEO at Trump Tower in New York, at which the AMI CEO, David Pecker, agreed to help Trump's campaign, saying that he would act as its eyes and ears by looking out for negative stories about Trump and alerting Mr. Cohen to them. Mr. Pecker also agreed to publish negative stories about Trump's competitors. And normally in a campaign situation, this would be something that the campaign would pay for. It's a thing of value. One of the components of this scheme, for example, was that at Trump's request, Michael Cohen, who then worked for the Trump Organization as special counsel to Donald Trump, covertly paid $130,000 to an adult film actress shortly before the election to prevent her from publicizing a sexual encounter that she had with Trump, allegedly. Michael Cohen paid the $130,000 payment through a shell corporation that he set up and funded at a bank in Manhattan solely for the purpose of disguising the true purpose of the payment. Mr. Cohen has since pleaded guilty to making an illegal campaign contribution for these actions, and he has since served time in prison because he followed Donald Trump's directions. Now, Trump insisted that he not reimburse Michael Cohen until after taking office on January 20th, 2017. And after the election, Donald Trump reimbursed Michael Cohen for this illegal payment of $130,000 through a series of monthly checks over a year. First from the Donald J. Trump Revocable Trust, and later from his personal bank account that was allegedly signed by him in the Oval Office at the White House. Now, each check was processed by the Trump Organization, and each check was disguised as a payment for legal services rendered in any given month in 2017, pursuant to a retainer agreement. The payment records that were kept and maintained by the Trump Organization were false New York business records, and in truth, there was no retainer agreement at all. And Michael Cohen was not being paid for legal services rendered in 2017. The defendant, Donald Trump, caused his entity's business records to be falsified to disguise his and others' criminal conduct. So Mr. Cohen and Alan Weisselberg of the Trump Organization, they have both spent time in prison for these illegal acts that were directed by their employer, Donald Trump. Direction that is supported by audio recordings and documentation provided by Michael Cohen and later released to the media and the prosecution. Mr. Weisselberg actually went to jail twice, once for doing illegal stuff and a second time for lying under oath about it. He is sitting in Rikers at this very moment. So why did they go to jail and not the guy who directed the criminal activity, Donald Trump? Well, simply because the United States Department of Justice has a policy against indicting a sitting president. And by the time we found out about all this, Trump was already sitting in the White House. So we've heard people say that the charges in this case are small, especially when compared to the other criminal cases that we're going to talk about today. But people are prosecuted for the crimes charged in this very case all the time, contrary to what the defense claims. Now, normally the charges in this hush money case are misdemeanors in New York, but these misdemeanors become felonies when they are done in furtherance of a separate underlying crime. What is that separate underlying crime? Well, the indictment says that Trump repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the election. So it seems fairly likely that the underlying crime that we'll see will be a campaign finance crime. But we'll learn a little bit more about that underlying crime once the jury is selected and the actual trial is underway. See, the hush money payments were essentially contributions that were made to Trump's campaign. It's not illegal to pay someone hush money, but if you do it as a part of an effort to win an election, it becomes automatically a thing of value. And a thing of value given to a campaign is a contribution, which comes with legal restrictions and reporting requirements on both the side of the donor and the campaign committee. And when those requirements are not met, a crime has been committed. And for good reason. Campaign expenditures are made public to the American people as a part of the open democratic process so that we know more about the candidates on the ballot when we go to the polls. But this theory only works if Trump paid this hush money to prevent damage to his campaign. Otherwise, no campaign law was violated. Trump's defense team insists that Trump only paid this hush money to keep it from his wife for personal reasons, who had been pregnant with their son at the time, and that's perfectly understandable. And if true, the payoffs would not be campaign contributions. But the prosecution has evidence that Trump told Michael Cohen to try to delay the payoffs until after the election, because then they wouldn't have to pay it, since it really wouldn't matter after he won the election. He said that he did not care if the women told their stories after he was elected to office. If the prosecution can show this to be the case, then it makes it more difficult for the defense to claim that the payments did not violate election law. But still, another possible underlying crime is that Trump intended to inflate and falsely characterize the reimbursement to Cohen in an effort to manipulate the Trump organization's tax consequences. Now, I'm not an attorney, but I don't see why the prosecution couldn't say that both of these underlying crime theories are true. We'll find out. I will not be covering any of the civil cases that have recently happened, the E. Jean Carroll case, defamation case, and the recent Trump Organization civil fraud case, because, well, we just don't have the time. We barely have enough time to touch on all 4 criminal prosecutions. I think we would probably need an entire semester to cover all the cases. A lot of people have said that these cases are politically motivated, but that's not necessarily the case. And we know this because by the day that Trump was inaugurated after the election, he had already been a party to over 4,000 lawsuits in his career. Just to give you a basic idea of what that looks like, that's basically one lawsuit for every day in Donald Trump's life for the 11 plus years before he got elected. One lawsuit for every day for over 11. That's a lot of lawsuits. So why so many? And how is it possible that the American people agreed to elect someone who was surrounded by so much controversy? Or was that controversy one of the reasons why he was elected? Moving on to the federal election case. The next two cases we're going to talk about arise out of the same alleged criminal activity intended to subvert or overturn the results of the 2020 election. One of them is a federal case, and one of them is a state case out of Georgia. But they all arise out of the same narrative story. So that narrative that I'm about to share is composed of information primarily taken from the federal indictment itself, some of it summarized and paraphrased by me, and some of it I'll just quote directly from the charging document. We fast forward 4 years from the events of the New York criminal case to the next election in 2020 and to the events as alleged in the Department of Justice's criminal indictment of Donald Trump, defendant in the federal election case out of the Washington, D.C. District Court. The indictment explains how, despite having lost the 2020 presidential election, former President Trump was determined to remain in power. So for more than 2 months following Election Day, Donald Trump spread lies that there had been outcome determinative fraud in the election and that he had actually won. These claims were false, and he knew that they were false, but he repeatedly and widely disseminated them anyway to make his knowingly false claims appear legitimate, create an intense national atmosphere of mistrust and anger, and erode public faith in the administration of the election. Now, Donald Trump had every right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He was also entitled to formally challenge the results of the election through lawful and appropriate means, such as by seeking recounts or audits of the popular vote in states or filing lawsuits challenging ballots and procedures. Indeed, in many cases, he pursued these methods of contesting the election results. His efforts, however, to change the outcome in any state through recounts, audits, or legal challenges were uniformly unsuccessful. Shortly after Election Day, Trump also pursued unlawful means of discounting legitimate votes and subverting the election results. In so doing, he perpetrated 3 additional criminal conspiracies. 1, a conspiracy to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected, counted, and certified by the federal government, also known as the federal government function. 2, a conspiracy to corruptly obstruct and impede the January 6th congressional proceeding at which the collected results of the presidential election are counted and certified, in violation of 18 U.S.C. section 1512K. And 3, a conspiracy against the right to vote and to have one's vote counted, in violation of 18 U.S.C. section 241. Each of these conspiracies, which built on the widespread mistrust that Donald Trump was creating through pervasive and destabilizing lies about election fraud, targeted a bedrock function of the United States federal government. The nation's process, like I said earlier, of collecting, counting, and certifying the results of the presidential election. Trump enlisted 6 co-conspirators to assist him in his criminal efforts to overturn the legitimate results of the election and retain power. The indictment does not list the actual names of each co-conspirator, but it describes them well enough for us to guess who they are based on facts that we already know to be true. These co-conspirators include attorneys like Rudy Giuliani, John Eastman, Sidney Powell, and Kenneth Chesebro, a former Justice Department official named Jeffrey Clark, and a political consultant believed to be Boris Epshteyn. Trump's conspiracy to impair, obstruct, and defeat the federal government function through dishonesty, fraud, and deceit included the following manner and means. 1. Donald Trump and his co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to subvert the legitimate election results and change electoral votes for Trump's opponent, Joe Biden, to electoral votes for Trump. That is, on the pretext of baseless fraud claims, Trump pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in his favor. 2. Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states. They were Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, attempting to mimic the procedures that the legitimate electors were supposed to follow under the Constitution and other federal and state laws. This included causing the fraudulent electors to meet on the day appointed by federal law on which legitimate electors were to gather and cast their votes, cast fraudulent votes for Trump, and signed certificates falsely representing that they were legitimate electors. Some fraudulent electors were tricked into participating based on the understanding that their votes would only be used if Trump succeeded in outcome determinative lawsuits within their state, which Trump never did. Donald Trump and his co-conspirators then caused these fraudulent electors to transmit their false certificates to Vice President Mike Pence and other government officials to be counted at the certification proceeding on January 6th. 3. Trump and co-conspirators attempted to use the power and authority of the Justice Department to conduct sham election crime investigations and send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome, that sought to advance Trump's fraudulent elector plan by using the Justice Department's authority to falsely present the fraudulent electors as a valid alternative to the legitimate ones, and that urged on behalf of the Justice Department the targeted states' legislators to convene to create the opportunity to choose the fraudulent electors over the legitimate electors. 4. Trump and his co-conspirators attempted to enlist the vice president to use his ceremonial-only role at the January 6th certification proceeding to fraudulently alter the election results. First, using knowingly false claims of election fraud, Trump and co-conspirators attempted to convince Vice President Mike Pence to use Trump's fraudulent electors, reject legitimate electoral votes, or send legitimate electoral votes to state legislators for review rather than counting them. And when that failed, on the morning of January 6th, Trump and co-conspirators repeated knowingly false claims of election fraud to gathered supporters, falsely told them that the vice president had the authority to and might alter the election results, and directed them to the Capitol to obstruct the certification proceeding and exert pressure on the vice president to take the fraudulent actions that the vice president had previously refused to take. 5, after it became public on the afternoon of January 6th that the vice president would not fraudulently alter the election results, a large and angry crowd, including many individuals who Trump had deceived into believing that the vice president could and might change the election results, violently attacked the Capitol and halted the proceeding. As violence ensued, Trump and co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification based on those claims. Those claims were false, and Trump knew that they were false. In fact, he was notified repeatedly that his claims were untrue, and often by the people on whom he relied for candid advice on important matters, and who were the best positioned to know the facts, and he deliberately disregarded the truth. Trump widely disseminated his false claims of election fraud for months, despite the fact that he knew, and in many cases had been informed directly, that they were not true. Trump's knowingly false statements were integral to his criminal plans to defeat the federal government function, obstruct the certification, and interfere with others' right to vote and have their votes counted. He made these knowingly false claims throughout the post-election time period. Now, since the indictment was issued, there have been several major developments in this case with historical importance, the most important of which began with a claim of presidential immunity from criminal prosecution by Trump. Judge Tanya Chutkan rejected that claim, holding that presidents are not issued a lifelong get-out-of-jail-free pass. Judge Tanya Chutkan then put the case on hold while Trump appealed that order. While a 3-judge panel of the D.C. Circuit Court of Appeals considered that appeal, the Supreme Court rejected Jack Smith's request to provide an immediate emergency answer to the immunity question. A week later, they were denied cert. But a week later, the Circuit Court issued a unanimous decision rejecting Trump's immunity claim and upholding Judge Chutkan's order. In response, Trump petitioned the Supreme Court to consider the question. The court granted his writ of certiorari, but scheduled the oral arguments for April 25th, several weeks away from the day they granted cert, reducing the chances that the case would make it to trial before the election in November. Until we know how the Supreme Court will rule on the immunity question, the fate of Trump's criminal charges, and frankly our republic, is up in the air. All right, we're moving on. The Georgia election case, like I said before, it's based on the same narrative and the same criminal activities that were committed in the federal case. But the federal elections indictment detailed numerous actions taken by Trump and his co-conspirators in each of the 7 targeted states in furtherance of the conspiracy to subvert the true election results and stay in office. Now, while I did not include specific examples of how these things were done in each of the targeted states, you can read about them more in that federal indictment. But there was one state that Trump targeted more than the others, probably because it was so close. And that is the state that ended up indicting Donald Trump and 18 co-conspirators in the next election case we're going to talk about, the state of Georgia v. Donald J. Trump et al. Now, the Georgia elections case, like I said, it stems from the same criminal scheme, but it charges the defendants for violating similar Georgia laws prohibiting the same conduct. However, the Fulton County, Georgia prosecutor in charge of the case took a slightly different approach than that of Special Prosecutor Jack Smith. In addition to charging the defendants with individual crimes, Prosecutor Fonnie Willis alleged that Trump's scheme was actually a criminal enterprise involved in racketeering in violation of Georgia's Racketeer Influenced and Corrupt Organizations Act, or Georgia's version of a RICO statute. Numerous acts are outlined in the indictment as part of this enterprise's scheme to subvert the results of the election, but the most shocking and memorable of all was Donald Trump's phone call to Georgia's Republican Secretary of State, Brad Raffensperger, in an attempt to enlist him in Trump's criminal enterprise. Now, the entire phone call lasted for over an hour, but I think that you'll really want to hear if you haven't already heard it. So what I did was I prepared a selection of audio clips that seemed to have provoked the greatest response when the audio of the call became public. It's about 6 minutes long. We'll listen to it because I think that it's really worth a listen. So get cozy.
We have won this election in Georgia based on all of this. And there's nothing wrong with saying that, Brad. You know, I mean, the people of Georgia are angry. And these numbers are going to be repeated on Monday night. We have won this election in Georgia based on all of this. And there's nothing wrong with saying that, Brad. You know, I mean, the people of Georgia are angry. And these numbers are going to be repeated on Monday night, along with others that we're going to have by that time, which are much more substantial even. And the people of Georgia are angry. The people of the country are angry. And there's nothing wrong with saying that, you know, that you've recalculated, because the 2,236 and absentee ballots, I mean, they're all exact numbers that were done by accounting firms, law firms, etc. And even if you cut them in half, and cut them in half again, it's more votes than we need.
Well, Mr. President, the challenge that you have is the data you have is wrong. We talked to the congressmen, and they were surprised, but I guess there was a person named Mr. Raynard that came to these meetings and presented data. And he said that there was dead people, I believe it was upward of 5,000. The actual number were two people that were dead that voted. And so that's wrong. That was two.
Well, Cleta, how do you respond to that? Now, do you think it's possible that they shredded ballots in Fulton County? Because that's what the rumor is. And also that Dominion took out machines. That Dominion is really moving fast to get rid of their machinery. Do you know anything about that? Because that's illegal.
This is Ryan, Germany. No, Dominion has not moved any machinery out of Fulton County. We're having.
But have they moved? Have they moved the inner parts of the machines and replaced them with other parts?
No.
You sure, Ryan?
I'm sure, Mr. President.
Mr. President, the problem you have with social media, people can say anything.
No, this isn't social media. This is Trump media. It's not social media. It's really not. It's not social media. I don't care about social, but I couldn't care less. Social media is big tech. Big tech is on your side. You know, I don't even know why you have a side, because you should want to have an accurate election. And you're a Republican.
We believe that we do have an accurate election.
No, you don't. No, you don't. You don't have. Not even close. You're off by hundreds of thousands of votes because you know what they did and you're not reporting it. That's a criminal offense. And you can't let that happen. That's a big risk to you and to Ryan, your lawyer. That's a big risk. But they are shredding ballots, in my opinion, based on what I've heard, and they are removing machinery, and they're moving it as fast as they can, both of which are criminal fines, and you can't let it happen, and you are letting it happen. I'm notifying you that you're letting it happen. So, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have. So tell me, Brad, what are we going to do? We won the election, and it's not fair to take it away from us like this. And it's going to be very costly in many ways. And I think you have to say that you're going to re-examine it, and you can re-examine it, but re-examine it with people that want to find answers, not people that don't want to find answers. For instance, I'm hearing Ryan, and he's probably, I'm sure, a great lawyer and everything, but he's making statements about those ballots that he doesn't know. But he's making them with such, he did make them with surety, but now I think he's less sure, because the answer is they all went to Biden. And that alone wins us the election by a lot. You know, so.
Mr. President, you have people that submit information, and we have our people that submit information, and then it comes before the court, and the court then has to make a determination. We have to stand by our numbers. We believe our numbers are right.
Well, under law, you're not allowed to give faulty election results, okay? You're not allowed to do that, and that's what you've done. This is a faulty election result. And honestly, this should go very fast. You should meet tomorrow, because you have a big election coming up, and because of what you've done to the president, you know, the people of Georgia know that this was a scam. And because of what you've done to the president, a lot of people aren't going out to vote. And a lot of Republicans are going to vote negative because they hate what you did to the president, okay? They hate it. And they're going to vote. And if you would be respected, really respected, if this thing could be straightened out before the election. You have a big election coming up on Tuesday. I mean, look, you'd have to be a child to think anything other than that. Just a child. I mean, you have your never Trump U.S. attorney there.
How many ballots, Mr. Secretary, are you saying that were processed in?
We had GPI thoroughly investigate that.
We had this is Ryan Germany, we had our law enforcement officers talk to everyone who was there after that event came to light. The GBI was with them as well as FBI agents.
Well, there's no way they could find, then they're incompetent. They're either dishonest or incompetent, okay? There's only two answers, dishonesty or incompetence. I would like you to, for the attorneys on my side, I'd like you to perhaps meet with Ryan, ideally tomorrow, because I think we should come to a resolution of this before the election. Otherwise, you're going to have people just not voting. They don't want to vote. They hate the state. They hate the governor, and they hate the Secretary of State. I will tell you that right now. And the only people that like you are people that will never vote for you. You know that, Brad, right? They like you, you know. They like you. They can't believe what they found. They want more people like you. So look, can you get together tomorrow? And Brad, we just want the truth. It's simple.
They're either lying or they're, what was the other option? Incompetent. Okay. So in March, after the indictment, Fulton County Superior Court Judge Scott McAfee quashed 3 of the original 13 counts against Donald Trump. Those 3 counts charged Trump with soliciting public officers to violate their oaths. And one of those counts came out of the call that we just heard, and that was dropped. But the RICO count still remains intact for Donald Trump, as well as 9 other counts he's charged with, including filing false documents and statements and various conspiracy charges. Now, on its own, so remember, he's got the RICO, which is just one of the counts, and then he's got 9 other counts. Just the RICO charge alone has a mandatory minimum penalty of 5 years in a Georgia prison. It's a mandatory minimum and a maximum of 20 years. You can't get any more than 20 for it. So that's quite a penalty there. And since these are state crimes, any possibility of a pardon is determined not by the President of the United States, not by the governor of Georgia, but by the Georgia State Board of Pardons and Paroles. There are only 4 states who don't give their governors the authority to grant pardons or grant clemency for state crimes, and they are Nebraska, Utah, Nevada, and, you guessed it, Georgia. But Georgia's governor can, to maintain some influence, however, appoint members to the Board of Pardons and Paroles. Several defendants charged in this indictment have pleaded guilty and cooperated with the prosecution, and several others have tried to get their charges moved to federal court without any success. Judge McAfee has yet to set a date for the trial. I think that he's waiting to see what happens in the Supreme Court. And meanwhile, we all hold our collective breath to see if the Supreme Court decides that our Constitution has an authoritarian loophole, if you will. All right. 3 down, 1 to go. Okay, so documents case. Again, Jack Smith is also the special counsel here. This guy is probably like the busiest guy on the planet. On January 20th, at the end of the president's final term in office, the presidential records of the administration are automatically transferred to the legal custody of the Archivist of the United States and the National Archives and Records Administration, or NARA. The records are usually eventually housed in a presidential library maintained by NARA. The National Archives and Records Administration preserves, reviews, arranges, describes, and makes available these records in its role as legal custodian. The Presidential Records Act, or PRA, defines and establishes public ownership of presidential and vice presidential records once they leave office, and the PRA requires that the president and his staff maintain separate files for personal records and presidential records. The PRA does not have anything to do with classified documents. I'm going to repeat that one more time. The Presidential Records Act does not have anything to do with classified documents. Just remember that going forward, because you're going to hear a lot more about this soon if you haven't already. It also doesn't have anything to do with this case. Classified documents are governed pursuant to executive orders, such as Executive Order 12958, signed in 1995, as amended by Executive Order 13292 in 2003, and Executive Order 13526 on December 29th, 2009. The Espionage Act also governs some of the classified documents policies as well. So then why, if this doesn't have anything to do with this case, why do I even bring it up? Well, because Donald Trump has repeatedly and falsely asserted that the Presidential Records Act allowed him to take all of the documents that he ended up taking after he left the White House. A quick look at the PRA reveals that the act says absolutely nothing that Donald Trump said that it says. Even if the documents Trump took from the White House were unclassified, unless they were strictly personal, like a diary or family photographs, things like that, the PRA would still not have allowed the president to take them, because the moment that a president's term is over at 12:01 p.m. on his successor's inauguration day, all the presidential records from his administration are transferred to the ownership of the American people and maintained by NARA. So I just wanted to clear up any misinformation and clarify what the PRA does not do before getting into this next case, having to do with documents that have been classified for national security purposes. With that in mind, let's move on to this fourth final case, United States v. Donald Trump et al. Out of the United States District Court for the Southern District of Florida, commonly known as the classified documents case. Now, as the 45th President of the United States, from January 20th, 2017 until January 20th, 2021, Donald Trump had lawful access to the most sensitive classified documents and national defense information gathered and owned by the United States government, including information from the agencies that comprise the United States intelligence community and the United States Department of Defense. Over the course of his presidency, Trump gathered newspapers, press clippings, letters, notes, cards, photographs, official documents, and other materials in cardboard boxes that he kept at the White House. But Donald Trump is not being dragged into federal court on the quest to find missing White House tchotchkes and memorabilia. That's not why he's being dragged into court. He has been indicted because among the materials that Trump stored in those boxes were hundreds of classified documents that he was no longer authorized to have, including some that were known to be in his possession and some that were just simply known to be missing. The classified documents that Trump stored in his boxes included information regarding defense and weapons capabilities of both the United States and foreign countries, mostly our allies, United States nuclear programs, potential vulnerabilities of the United States and its allies to military attack, and plans for possible retaliation in response to a foreign attack. The unauthorized disclosure of these classified documents could put at risk the national security of the United States, foreign relations, and the safety of the United States military and human sources, and the continued viability of sensitive intelligence collection methods. Oh, I think the last semester I had made a comment that I think if you have enough money to have a crystal chandelier in your bathroom, that you should not have a cheap shower curtain. You should have something, step it up a little bit, right? So on January 20th, again, Inauguration Day at 12 o'clock, Trump ceased to be president. And as he departed the White House, Trump caused scores of boxes, many of which contained classified documents, to be transported to the Mar-a-Lago Club in Palm Beach, Florida, where he maintained his residence. Now, like I said earlier, he was not authorized to possess or retain those classified documents. Just so you have an understanding of what it's like at Mar-a-Lago, it's an active social club. So probably not the best place to keep, sensitive information from foreign spies or something. And in 2022, it hosted events for tens of thousands of guests over the full year. After Trump's presidency, the Mar-a-Lago Club was not an authorized location for storage, possession, review, or display of classified documents, but nevertheless, Trump stored his boxes containing classified documents in various locations at the Mar-a-Lago Club, including a ballroom, a bathroom and a shower, an office space, his bedroom, and a storage room. So the United States Secret Service, former presidents get Secret Service protection for themselves and their family, but the Secret Service in this case was not responsible for the protection of these boxes or their classified contents. And in fact, Trump didn't even inform the Secret Service that he was storing boxes containing classified documents at the Mar-a-Lago Club. So there was really nothing that they could do to lend a hand to make sure, spies didn't steal secrets or something. Like under pipes, on 2 occasions in 2021, Trump showed classified documents to other people as follows. In July 2021 at Trump National Golf Club in Bedminster, New Jersey, during an audio recorded meeting with a writer, a publisher, and 2 members of his staff, none of whom possessed security clearances, Trump showed and described a plan of attack that Trump said was prepared for him by the Department of Defense and a senior military official. Trump told these individuals without clearances in the room that the plan was indeed highly confidential and secret. He also admitted, and this is on tape, as president, I could have declassified it, And now I can't, So this is still a secret. In August or September 2021 at the Bedminster Club, Trump showed a representative of his PAC, his Political Action Committee, who did not possess a security clearance or a need to know. He showed him a classified map relating to a military operation that was currently underway and told the PAC representative that he really shouldn't be showing him the map and that he shouldn't get too close. On March 30th, 2022, the FBI opened a criminal investigation into the unlawful retention of these classified documents. A federal grand jury investigation began the very next month, and that grand jury issued a subpoena requiring Trump to turn over all the documents with classification markings. Now, they're not asking for, maybe a letter from a foreign dignitary that should have been given to Nara or a couple of gifts or tchotchke. They're asking only for these classified documents back. But even after asking them and subpoenaing them, Trump still endeavored to obstruct the FBI and grand jury investigations, and he lied to conceal his continued retention of classified documents by, among other things, 1, suggesting that his attorney falsely represent to the FBI and the grand jury that Trump did not have documents called for by the grand jury subpoena. So just lie and say we don't have them. 2, directing defendant Walt Nauta to move boxes of documents to conceal them from Trump's attorney. So he wanted to hide them not just from the FBI, but from his own attorney too, and the grand jury. 3, suggesting that his attorney hide or destroy documents called for by the grand jury subpoena. 4, providing to the FBI and grand jury just some of the documents called for by the subpoena, while claiming that that's it, there's nothing left. 5, causing a certification to be submitted to the FBI and grand jury, falsely representing that all of the documents called for by the subpoena had been produced, while knowing that, in fact, not all such documents had been produced. 6, attempting to delete security camera footage at the Mar-a-Lago club in an effort to conceal information from the FBI. 7, as a result of Trump's retention of these classified documents after his presidency and his refusal to return them, hundreds of classified documents were not recovered by the United States government until 2022. On January 17th, nearly 1 year after Trump left office, and after 4 months of demands by NARA for Trump to provide all of the missing presidential records and classified documents, Trump provided only 15 boxes, which contained 197 additional documents with classification markings. On June 3rd, in response to a grand jury subpoena demanding the production of all documents with classified markings, Trump's attorneys provided to the FBI yet another 38 more documents with classified markings. Then on August 8th, pursuant to a court-authorized search warrant, the FBI recovered from Trump's office and a storage room at Mar-a-Lago 102 more documents. It was just like, oh no, this is it. And then like every few days, they find more and more. These are the rest of the boxes. Look at all those boxes. Now in this picture, these are top secret SCI documents that are just, I mean, I know that the people who threw these on the floor, it wasn't Trump, it was actually during the search, but these types of documents, they need to be viewed in a secure, compartmentalized facility called a SCIF. So with that, where are we at on time? Okay, cool. So we have the rest of the time to talk.